matter of Secretary of State for Business and Trade against Mercer.
Lady Simler will explain the decision of the court.
Employees dismissed for taking part in lawful strike action have some statutory remedies for unfair dismissal, but there is no express statutory or other protection in domestic law against action taken by an employer short of dismissal for participation in a lawful strike. The question on this appeal is whether Section 146 of the Trade Union and Labour Relations Consolidation Act 1992 can be interpreted to provide such protection, and if not, what is the consequence? The appellant, Ms. Mercer, was employed as a support worker in the care sector by a care services provider. She was also a workplace representative of UNISON and was involved in planning and took part in a lawful strike. She was subsequently suspended by her employer and, while suspended, received normal pay, but couldn't earn additional payments for overtime she would otherwise have worked. She brought a claim under Section 146 of the 1992 Act. This section protects a worker against detrimental treatment by their employer done with the sole or main purpose of preventing or deterring that person from taking part in the activities of an independent trade union, but only if done at an appropriate time. Ms. Mercer alleged, among other things, that she'd suffered detrimental treatment done for a prohibited purpose. She argued her participation in a strike was done at an appropriate time. She also relied on Article 11 of the European Convention on Human Rights, which protects the right to form and join a trade union and qualifies the restrictions that can be placed on the exercise of those rights. This part of her claim was decided as a preliminary issue without determining the facts. The Employment Tribunal held that Section 146 couldn't be interpreted in a way that gave her the protection she sought. The Employment Appeal Tribunal reversed that conclusion. The Court of Appeal allowed a further appeal by the intervener, the Secretary of State for Business and Trade, holding that Section 146 couldn't be interpreted compatibly with Article 11 of the Convention, but refusing to make a declaration of incompatibility. Ms. Mercer now appeals to the Supreme Court. The Supreme Court agrees with the Court of Appeal about the interpretation of Section 146, but unanimously allows the appeal to the extent that it makes a declaration that Section 146 of the 1992 Act is incompatible with Article 11 of the Convention. I give the judgment of the Court with which the other justices agree. Adopting a domestic interpretation, the words of Section 146 do not extend to cover participation in a lawful strike. This is because the words "at an appropriate time" are defined to exclude working time except with the employer's consent. Protection is limited to activities which are outside working hours or done at a time that's not inconsistent with a worker's job responsibilities in working time. Lawful strike action normally takes place during working hours if it is to have the desired effect, since for workers to withhold their labour outside working hours is unlikely to have any consequence for an employer. It's not therefore protected by Section 146. There are other provisions in the 1992 Act that support this conclusion, and they are discussed in the judgment. The Supreme Court had therefore to consider whether this absence of protection for workers taking part in a lawful strike against detriments short of dismissal is compatible with Article 11 of the Convention. The cases decided by the European Court of Human Rights show that although the right to strike is protected by Article 11, it's not a core right, nor is it absolute. In cases like this, concerning a state's positive obligations to legislate to protect the right to strike as between private employers and workers, the European Court of Human Rights has recognised the discretion to be afforded to states in deciding what legislation to pass in an area that raises sensitive social and political issues. The UK is not required to provide universal protection in all circumstances to all workers against any detriment, however slight, that is intended to dissuade or penalise them for participating in a strike. But at the same time, any legislative scheme must strike a fair balance between the competing interests of employers and workers, and any restrictions on the exercise of Article 11 rights must be justified, recognising that discretion afforded to states in striking the balance. Since domestic law doesn't provide any protection for workers faced with disciplinary sanctions short of dismissal for taking part in a lawful strike, employees cannot strike without exposing themselves to detrimental treatment. That effectively nullifies the right to strike. Had there been legislation addressing such detrimental treatment, it might have been possible to say that a fair balance had been struck. The failure to provide any such protection puts the UK in breach of its positive obligations to secure the effective enjoyment of Article 11 rights. The Supreme Court agrees with the Court of Appeal that even having regard to the strong interpretive obligation in Section 3 of the Human Rights Act, however, which requires senior courts to interpret primary legislation compatibly with the Convention, it's impossible to interpret Section 146 in a way that is compatible with Article 11 of the Convention. The Court would have to make policy choices with potentially far-reaching practical ramifications, which would amount to impermissible judicial legislation rather than interpretation, and which would contradict a fundamental feature of the legislative scheme because of those words, appropriate time. The Court of Appeal held in these circumstances that it couldn't make a declaration of incompatibility under Section 4 of the Human Rights Act because the incompatibility arose from a gap in domestic law rather than from a specific provision in primary legislation. The Supreme Court disagrees with that conclusion. Section 146 is the only route available to Ms. Mercer to vindicate her Article 11 rights in the domestic courts or tribunals. But that route is blocked by the conventional interpretation given to Section 146, and that is what is inherently objectionable in the terms of Section 146 as it stands. This court has discretion as to whether to make a declaration of incompatibility. There may be cases where it's not appropriate to do so, but this is not such a case. The policy choices required in determining how to strike a fair balance between the competing interests at stake will be for Parliament, but that's not a basis for refusing to make a declaration in this case. The Court therefore makes a declaration under Section 4 of the Human Rights Act that Section 146 of the 1992 Act is incompatible with Article 11 of the Convention, insofar as it fails to provide any protection against sanctions short of dismissal that are intended to deter or penalise trade union members from taking part in a lawful strike organised by their trade union.
The Court will adjourn.